All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for this important session on supportive decision making. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You will receive a copy of this recording in an email via Zoom. It's not going to come from me, it's going to come from Zoom, and it's going to be within 24 hours after it ends. If you don't see that email, I'm gonna drop my email here in the chat for multiple reasons, but anything that you may need, recording or anything else, you can feel free to reach out to me. This training was approved by the Florida Bar for 1.5 general and 1.5 juvenile law certification credits. I'll announce the CLE code towards the end. I will also drop the code in the chat, and I will also include it in that Zoom email. It will be in the YouTube description as well. And if you do need a certificate of completion and attendance, or you have any other questions, feel free to contact me. I'm gonna drop my email in the chat as well. I know Alexis used to do this, but I'm gonna be covering this moving forward. So if you accidentally email Alexis, you will probably forward it to me. So closed captions are enabled for anybody who needs them. If you're having any issues with accessibility, just let me know and you can reach out to me directly. And final piece of housekeeping announcements is the questions and answers. If you do have any questions during the presentation, feel free to use the Q&A feature. We'll do our best to, if the question is relevant to the topic that is being discussed, to address the question live. We'll also try to answer the questions on the Q&A feature, and that information is captured. So I'll make sure to share that information with the materials as well. So I'm gonna go ahead and to introduce this great speaker lineup today. We have 3 speakers, so I'm gonna try to keep the bios a little bit short, but you might wanna take a look at their bios if you haven't in the registration because they're very impressive. So starting off with Robin Rosenberg. Robin became the Deputy Director of Florida's Children's First in April 2007. Prior to joining the staff, Ms. Rosenberg was a founding board member of the organization and served as Secretary and Litigation Committee Chair. Prior to joining Florida Children's First, she worked for almost 10 years at Holland and Knight, serving on the firm's community services team for the last 7 years. Ms. Rosenberg clerked in the United States District Court for the Middle District of Florida for Senior Judge William Castagna and Judge Henry Lee Adams. Our next speaker is C. Christine Smith. Christine is the newest addition to Florida's Children's First, serving as the first staff attorney to represent children and young adults. Christine graduated with honors from Stetson University College of Law in 2006. After law school, Christine began her career in child advocacy at the L. David Shear Children's Law Center at Bay Area Legal Services, a nonprofit children's law center. In 2011, Christine joined the firm of Hernandez and Smith as a partner focusing on juvenile and family. And our last speaker is Caitlin Cliven. Caitlin is the director of the Community and Healthcare Services team at Disability Rights Florida. Caitlin's work is primarily focused on issues related to healthcare and community inclusion. In her previous position as a policy analyst at Disability Rights Florida, Caitlin assisted with drafting and promoting the supportive decision-making bill that has now become law. As a social worker turned lawyer, Caitlin has spent her entire career in public service and has held several positions, professional and volunteer, advocating for and representing others. So without further ado, I'm pleased to pass it over to Robin so she can get it started. Robin, the floor is yours.
Thank you very much, Jorge. Good afternoon, everyone. We are so glad you could join us today for this really important webinar. We are going to start with a little pitch for the Florida Dependency Law Center. If you're an attorney or judge, you can join the Dependency Law Center at no charge, and it's a great resource on what's happening in dependency. We operate a listserv that promotes information about trainings and other documents and things that are useful to you. It is free to join, floridadependencylaw.org. Okay, commercial is over. What we're going to talk about today, here's our agenda. Christine is going to talk to you about the Regis Little Act. Caitlin's going to talk to you about supported decision-making. Then Christine is going to integrate how you can use supported decision-making in your dependency practice. And we'll wrap up where I will work with you on some examples, some case examples to think about how we would apply this in the real world. But first, there's 130 of you that are on right now. And I'd like to get a sense of your experience with using the decision-making options for young people in Regis Little cases. So if you could take the poll question that just popped up and you can answer multiple answers. What have you used with young people that you've been working with in dependency law? If you've done guardianships or guardian advocacy, please take a minute and check off the boxes so that we can kind of get a sense for folks' experience with using these decision-making supports. And we will hold it just one more second. So hopefully the poll popped up and is easy for you to take control of. All right, can we see the answers that we have so far? Okay, I'm going to show it. Hopefully you guys see it on your screen. Okay, so almost half of you have had a case that's gone to guardian advocacy and a little over a third to guardianship. And lower in the 20% range for informal, limited, and representative payee. Okay, and other, we didn't give you an option to explain what the other is, but we'll have some opportunity to do that later. Thank you for participating in the poll. I'm going to turn it over to Christine to start on Regis Little.
Yes, good morning, everybody. We're going to start with the review of the Regis Little Act and what happens when a child with an intellectual disability ages out of foster care. Next slide. A little history behind the act. In 2008, there was a really tragic death of a former teen foster youth who was stabbed to death in Orange County shortly after he aged out of foster care system. So that really tragic circumstance and that death led to, in 2015, the Regis Little Act. There was a gap that did not adequately address what happened when a teen would age out of the system. So the Regis Little Act was passed to give a guideline, to give statutory framework to how we can help kids and teens with disabilities aging out of the system in the least restrictive way possible. And we want to really key in on that idea of the least restrictive way possible. And I think the new supported decision making really gives a little bit further definition to how we can help kids and teens with disabilities in that least restrictive way possible, rather than in the poll. We had a lot of variation between how you do it. If you don't do a guardianship advocacy, if you don't do a plenary guardianship, the supported decision-making legislation that just came out gives a little bit more shape to how we can help kids in that least restrictive way possible. So next slide. So a little bit more about Regis Little, and you may see, you know, the facts play out a little bit in your cases if you have worked with teens that are similar in a fact pattern to what was going on with Regis. At the time of his death, he was 18 years old. He had an IQ of 65. He was on at least 5 psychotropic medications and had a mental health diagnosis. He had an extensive arrest record and he had no consistent person advocating for him. And as a result of all of those circumstances that were going in his life, he declined to accept any help from APD, which is the Agency for Persons with Disabilities. So now, under the Act, even though it's not new, it's been going on since 2015. This is a refresher for everybody what the requirements under the act are. We need an update to a case plan. When you're dealing with a teen, they should have an updated case plan to track the progress of what's happening in that case with that teen. There actually has to be a finding from the judge that whatever methodology that is going to be implemented, the judge must make a finding that that particular solution is the least restrictive means available for that child. We also have to identify supportive adults. And this was something that we kind of talked offline about, that the requirements allow biological parents to remain guardians unless the parents have had their rights terminated. When I was doing the slides and kind of refreshing my own self, that was something that in my personal practice I haven't been seeing. I haven't been seeing the biological parents involved in that process of being a supportive adult. If they've already had an adjudication, and it is possible, and they should be involved. Guardianship proceedings must be conducted in a separate proceeding and not in the dependency proceeding. And there's also a mechanism, a statutory requirement that we annually review the guardianship advocacy or the guardianship to see if it's still necessary, and that should be occurring until age 22. So when is the act relevant? So this is kind of issue spotting. When should we be doing what we need to be doing? So at the first judicial review after the age of 17, if the court determines there's a good faith basis to believe that a teen might meet the criteria for the appointment of a guardian advocate, a limited guardianship, or plenary, and again, that there's no less restrictive decision-making assistance available to that child, then DCF must complete a multidisciplinary report, including a psychosocial eval, and if one hasn't been completed in the past 2 years. So prior to that judicial review, everybody should be looking at the child's file and seeing if there's updates that need to happen so that they're ready for that judicial review. And DCF must identify potential adults who may be able to serve as a guardian advocate, limited guardian, or plenary guardian. The teen's parents, again, may serve as guardians if their rights haven't been terminated, but the court must enter a written order finding such that an appointment is in the best interest of a child. DCF must also identify a plan to initiate guardianship proceedings prior to the age of 18. So you can see there at the first judicial review after age 17, we should be getting these things in the works if they're not already in the works. And then if there is a plan to initiate the guardianship, we want to be doing that as soon as the 17-year-old JR to be canvassing for pro bono help, or for an attorney that could initiate a guardianship proceeding if it's needed. And again, we're looking at the less restrictive means, and so we should be looking at all of that during the teen's 17th year. Next slide. And so we saw that, is there a good faith basis to believe that the Regis Little Act applies? And here are some of the factors that you may see all of them, you may see one of them that may trigger you to believe there's a good faith basis that a teen might need some help in the form of a guardianship or in some new supportive decision-making, which are alternatives to guardianship. If that teen receives a Social Security disability, or is enrolled in the APD's budget waiver or any other kind of Medicaid waiver program, that might trigger an initial inquiry to see why. If they've had a prior assessment to indicate a lower IQ, if they've had a physical, mental, or an emotional condition that impacts the intellectual functioning, if they're in medical foster care. Not to say that every kid that's in medical foster care might need guardianship, but it's, again, these are just some trigger points that may lead to more inquiry. If they have had Medicaid coverage through CMS or Children's Medical Services, or if they have a diagnosed cognitive impairment or developmental disability. These are the statutory definitions of a developmental disability, meaning if you're going to file for a guardianship advocacy, Florida Statute 393-063-11 defines that developmental disability as something that is a disorder or a syndrome that's attributable to an intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermott syndrome, or Prader-Willi. All of those had to have manifested before the age of 18, and they constitute a substantial handicap that can be reasonably expected to continue indefinitely. So these are the different categories under the statute that would qualify for the guardianship advocacy. Next slide. But that's really only the starting point. We want to look at a little deeper on the definition of the intellectual disability, which was that first category, and see if there's significant sub-average general intellectual functioning that exists with deficits in the adaptive behavior in kids less than 18. And I would say we all know, if we've worked with kids and teens, that we should be looking at this through the trauma-informed lens, because kids that have endured trauma are not going to process things intellectually. Biologically, they might be 17, but because of the trauma that they've incurred in their lives, maybe they're processing at age, 14, 15, but that doesn't mean that they're so impaired that they can't learn to make better decisions as time goes on. So again, we go back to the least restrictive means. The adaptive behavior, this is kind of an interesting statutory definition, that it means the degree in which the individual meets the standards of personal independence and social responsibility expected of his age, cultural group, or in the community. And I think that when we look at that in the cultural group, in the community, and the age, I think we have to look at it in that trauma-informed lens to see, are the behaviors that we're seeing, the adaptive behaviors, are they a result of kids being put in a foster care home that they are feeling stuck in, and they feel like they have no agency in, and so they're acting out in different ways, or if it truly is an intellectual disability issue. And so if they have a significant sub-average general intellectual function, that's the statutory definition, that there are 2 or more standard deviations from that standardized intelligence. So be on the lookout. In general terms, a 70 or below IQ might trigger a good faith basis to believe that the Regis Little Act applies. So now we have new tools in our toolkit, and so we want to kind of rethink our framework in the Regis Little Act. Not all individuals who have those categorical diagnoses need a guardianship advocacy. In preparation for these slides, Rob and I were talking offline, and spina bifida was one of the categorical statutory definitions for guardianship advocacy, and she happens to have a friend with spina bifida that functions at a high IQ level. So that's not the categorical definition, is just the starting point to think if we have a good faith basis. But we also have to look at how does that individual behave? Do they have any cognitive impairments? There might be people that meet that categorical definition, but they may be able to independently function if they have a circle of support within this new framework of the supported decision-making agreement, or some of the other alternatives that we have that are least restrictive to a guardianship advocacy or guardianship. We have this supported decision-making legislation, I think, allows for a more unique and individual solution to help avoid guardianships. There's many other disabilities and conditions that could lead to that good faith analysis to consider what solution is the best. There's mental illnesses, disorders of seizures and traumatic brain injuries as examples, to where we may be looking at the Regis Little Act and exploring all the different tools that we have now with the supported decision making before we jump to a guardianship advocacy or plenary guardianship. And so with that, I will turn it over to Caitlin for the supported decision making.
Hi. Hey, thank you, Christine. So I'm Caitlin Clibben, and I'm with Disability Rights Florida, and I will talk about supported decision making. I'm going to try to keep it relatively simple. It's a simple concept, but please feel free to ask questions if you have any. Robin, can you move to the next? Thank you. So, first of all, just basically, what is supported decision making? I know it's new and not a lot of people have heard of it, but it is, it's not new itself. More than 20 other states have supported decision making laws passed, and it's also used internationally. So, at its core, it's meant to be an alternative to guardianship and guardian advocacy. The guardianship and guardian advocacy statutes require reasonable alternatives to guardianship be considered before a guardianship or guardian advocacy can be put in place. I'm going to shorten that and just say guardianship, but please know I'm talking about both when I'm saying guardianship. So the court has to consider alternatives before putting a guardianship in place. And so we've added a new alternative to our statutory list of alternatives with supported decision making. And so the way it works, what it is, how it works is that it's a collaborative process between the decision maker, who's going to be your person with a disability or a cognitive impairment, and then their supporters, the people they've chosen to help them. And the process is really one that everyone is familiar with. We all use it all the time. My favorite example is, when my car breaks down, I am not going to go out there and start banging on it and trying to fix it myself. I do not have the expertise required for that. So I call my dad and I ask my dad, hey, what's your advice? Can you help? Should I take it in? Blah, blah, blah. But when I wanted to buy a house, I called my mom, because my mom is the one who I trusted with those sorts of decisions and that sort of advice when I was buying my first house. So, you're in supported decision making, we're doing the same thing. We're just kind of calling on other people to help us weigh the pros and cons, understand the issue, and make a decision. But ultimately, we ourselves, the person themselves is making the decision for themselves. Robin? Okay, so again, Florida law favors alternatives. It's all woven throughout the legislative intent and the statutes in 393 and 744, where you find guardianship advocacy and guardianship. So we try to always look at alternatives first. And in Florida, those alternatives, it's supported decision making is now one of them. Also, the healthcare surrogate process, durable powers of attorney, and the representative payee option. Those are all considered alternatives right now. Next slide. Okay, so this graphic is it's got a lot of small words on it, and I'm sorry about that. And it's actually from Wisconsin, but it's meant just to kind of illustrate this kind of these graduated options. So it's a little blurry on here, I'm sorry, but all the way to the left, the blue blob says release form. So that's going to be your very least restrictive option there. If I sign release forms for my school to give information to my parent, you know, I've signed FERPA release forms, and I'm not giving up any decision-making authority. I'm not giving up any of my rights. I'm simply saying you can, you know, give this person information. That's the least restrictive. Next, in yellow, is supported decision-making. Again, we're not taking any rights from anyone. We're just entering into a formal agreement where they will receive support. In the middle, we have representative payee. That is, you know, kind of in the middle of restrictiveness, because you're not technically taking away rights, but what you're doing is you're appointing a person to manage their Social Security income. So for their decision-making ability in regard to those income, that income is now taken from them and given to another person. So that's moving into the realm of substitute decision-making, someone substituting their decision for your own. Next is power of attorney and medical proxy. Those are, you know, forms that we execute ourselves, and we choose who our power of attorney we want it to be, who we choose who we want our medical proxy to be. But those do, again, they do allow substitute decision-making. If you've become incapacitated, your medical proxy can make decisions for you without any input from you. And same with power of attorney. While you don't lose your right to make your own decisions, there's someone else who can also make decisions for you. And then all the way to the right in purple is our most restrictive options, which are limited or full guardianship. And then in Florida, also guardian advocacy. Not every state has a version of guardian advocacy, and those are considered most restrictive because they do remove people's rights in order for them to use them. Next slide, please. Okay, so here's another little chart that I made hastily, so I apologize if it's hard to read. But I wanted to compare the options that we have in Florida, you know, putting supported decision-making against these three guardianship options. So, you know, with SDM, you're not going to have to go to court. You execute the document yourself, and then you give it to whoever needs it, your doctor, your bank, whoever needs to know about the agreement. You don't have to record it anywhere. It shouldn't cost you any money. Easy peasy. And, you know, it allows the person to be helped by, you know, their trusted individuals. It helps them learn decision making. You're not taking away their rights. You know, they have their self-determination intact. And you can like couple it with other alternatives as well. So guardian advocacy is often seen as guardianship light, and, you know, the lesser form of guardianship. And I will just pose another thought about that. Coming from the disability rights perspective, you know, guardian advocacy removes your rights just like guardianship. So you're still having your rights taken away. And with guardian advocacy, there's not, you know, you're not required to have a finding of incapacity. So with guardianship, you have to go through an examining committee who checks, you know, checks you out and looks and tries to make a determination about your capacity to make decisions, and then makes a report to the judge, and the judge makes the decision. None of that has to happen in guardian advocacy. You simply have the developmental disability diagnosis, show it to the judge can order the guardian advocacy. And so in a way, it's kind of a swifter, more hasty path to getting your rights taken away. And, you know, I'm not saying that it's the devil or no one should ever use it, but just know that even though it's kind of seen as the more benevolent form of guardianship, it's still taking someone's rights to make their own decisions away. And so then on the right, you see limited guardianship and plenary guardianship. Really, the only difference between those is how many rights are taken away. Limited guardianship is going to be less than all. Plenary guardianship is going to be all. And I've listed out the different rights under plenary guardianship. Some are delegable. Some, you know, your guardian's going to do those things for you. Others are not delegable. You just simply cannot do those things. And your guardian can't do them for you. So your guardian can't force you to get married, force you to vote, or force you to travel or any of those things. But you can still have those rights removed, and then you just can't do those things. All right, next slide, please. Okay, so again, coming from the disability rights perspective, I know that I get a little bit of pushback on this sometimes, I will say, so feel free to ask questions or let me know if you're having thoughts about this. But, legally every person is competent unless a court says they're not. And I know that there are times when we have people who have not been determined incompetent by a court, but that we don't believe are competent to make their own decisions. I realize that this is a reality, but strictly legally speaking, if the court has not taken away your rights, you are competent. So unfortunately for people with disabilities, many people assume that just the very fact of them having a disability means they're not going to be able to make their own decisions. Christine gave that example of someone with spina bifida whose, intelligence or cognitive ability was not impaired at all, but they had a visible disability. And I'm sure there were many people who assumed that they, needed help making decisions, needed help, doing all sorts of things that they truly did not need help with. So many people with disabilities can make choices, even people with cognitive disabilities, with, developmental delays, can make choices. Sometimes their process looks different. For example, you might have a person who's just a slow processor, so they need to be told that thing 10 times. You can tell me it once, but they might need to hear it 10 times. They might need to hear it in 10 different ways in order to really put it together and understand what you're saying. And just because you take more time or you need more explanation does not mean that you're not able to, take the information and reason it and then make a reasoned decision. And I say reasoned decision because there's no requirement that people make good decisions. Guardianship and guardian advocacy come into play when a person cannot make decisions, not when they're making bad decisions. I think that most people would admit that at some point in their life, they have made a bad decision. If our bad decisions caused us to have a court intervene and take away our rights to make our own decisions, I think just about everyone would be under a guardianship, honestly. So, think about that when you're working with a person with a disability and, if they're trying to make a decision and they're trying to figure something out and they've made a wrong decision and, they bought that thing on Amazon at 2 a.m. and now they are over budget, who hasn't done that? It doesn't necessarily mean they need a guardianship now to protect them. They probably just need some more education and explanation about budgeting and helping them with that. So again, don't have to make only good decisions. We are trying to help, but nobody's perfect. And when we make mistakes, like that's how we learn. The first big mistake I made after passing the bar and getting my license and showing up to court and failing to have notified a party that should have been notified, I will never make that mistake again. It's seared into my brain. That on those types of challenges, you have to notify this party that you're filing. So, we learn from our mistakes. And when you don't let people make choices and don't let them make mistakes, they don't have that opportunity to learn from it. And at the bottom, just, people with disabilities are at their core people, just like everyone else. And, they deserve to be able to take risks and make mistakes and buy that thing on Amazon that's a little too much money and, have to return it later and learn from that, So, just some underlying concepts below, the idea that made us want to support supported decision-making in Florida. Next slide, please. Okay. So there have, like I said, there's 20-something, 22 other states-ish in the District of Columbia that have passed supported decision-making laws. It's been used in several other countries as well. And there's data, there's research on people who have used supported decision-making and how it turned out for them. And some of the positive correlations they found for people who began using supported decision-making is, first of all, obviously, it helps you preserve your rights. But it also helps people build their independence, get more and more independent over time as they practice decision-making and learn how to do it. It allows them to, make their own choices, which usually, people have more buy-in when they're making their own choices. I mean, we've all, I think, experienced, telling a teenager that they need to take a medication and they don't want to take it, or the teenager needs to do something, they don't want to do it. If it's their idea, they're more likely, if it's their choice, they're more likely to buy into that decision. It also helps prevent abuse and increases confidence. Those two things kind of go together. People who use supported decision-making, these studies have found that they are better able to identify abuse and they're more confident and better able to report it, to speak up, to say no if someone's asking them to do something that they don't want to do. It makes them feel like they have more agency and they're making decisions and they can say yes or they can say no. So it really helps reduce abuse for people with disabilities. And then also it's shown to increase their employment outcomes and their education outcomes. So better grades, higher level of achievement in educationally, and then more likely to become employed or to receive better employment or better pay over time. Next slide, please. Okay, so I'm gonna go through like the document itself in a moment. It's pretty simple, but when this is on how to use it generally, not the document itself, but the concept. So the supporters, it's really tailored to the individual. So you might have a situation where your supporters states away and everything's by phone. That is fine. You might have a thing where you're only really needing support on medical decisions, and really that only comes up once a year. So you might not talk to them every week or every month. Other people might rely on their supporters routinely on a daily basis. It's really depends on the individual and their circumstances and the agreement that they have made with their supporters. So it can be used in combination with other alternatives to guardianship. We often at Disability Rights Florida, when we're helping people create their supported decision-making agreement, we will tell them about healthcare proxies and powers of attorney as well, so they can decide if those things would be helpful in addition. And what I'm talking about here is kind of like a cascading set of alternatives. So, your supported decision-making agreement can be what you rely on and you're using supported decision-making, but, you're going to have a medical procedure soon, and you're going to be out for a week or more, kind of out of it. So during the time when you're out of it from your medical procedure, your healthcare proxy can kick in, and that proxy can make the decisions for you during that week. Once you're back at it and you've finished your medical situation, then you're back onto the SDM agreement, making your own decisions for yourself. Same thing with a durable power of attorney. And so technically the supported decision-making agreement, the way the law was passed this year, it is in the power of attorney statute, since it's in chapter 709, and it's a new type of power of attorney, but it's not durable. So what that means is it does not survive if you become incapacitated. So that's why we like to have the power of attorney and the healthcare proxy there alongside the SDM agreement, because if something happens, if your condition deteriorates, if you get in an accident, get a head injury, that supported decision-making is no longer valid, no longer usable. But your healthcare proxy and your power of attorney can kick in and be there for you and help prevent you having to have your rights removed. Again, agreements tailored to the individual. Okay, so the elements of the agreement, very easy. I'm going to go through this pretty quick. You want to have a written document if you're going to be trying to use this in court or a doctor's office or a bank or anything like that. Have it in writing. And, even though many people do this informally all the time, you designate your supporters. There can be as many supporters as you want. You might have a different supporter for each domain in which you're asking for help with. And you want to designate alternate supporters so that you don't have to redo the document if one of your supporters is no longer able to help. So, Auntie moved out of state and can't be my supporter anymore. I've already designated, my cousin instead. So no changes needed, nothing, you don't have to do anything. You just keep going like you've been going. And then we always include the basic info for the supported decision maker, just for identification purposes. We know who we're talking about. Next slide. So the meat of the agreement really is talking about how the supporter will help and in what areas they will help. So how they will help, these are the options here on the screen. They can help you gather the information. They can help you understand that information. They can help you explore which options may be available in whatever situation you're talking about. Figuring out what those options are, and then also helping you understand what those options mean, explaining the risks and benefits of each option. They can give you guidance, advice, recommendations. Here, what I would do if you would, if I were you. But then ultimately the decision maker makes their own decision And then the supporter can help them carry out the decision. The statute actually specifically says that the supporter can communicate the decision on the decision maker's behalf. So if you have someone who has difficulty communicating, as long as that's their decision, the supporter can say, okay, well, they've decided that they want to close this account, and they can be there with you to help you carry out that decision. But ultimately, it's still your decision. Next slide.
Caitlin, I'm just going to stop. There's a question in the Q&A. Who should be drafting the legal documents? Should the community-based care agency hire or find a pro bono attorney to do them?
Okay, good question. So I, as a lawyer, do not think people need lawyers for this. We have a template agreement on our website that we allow people to download and use. It's much like a power of attorney or a healthcare surrogate form. You can have an attorney to help you with that. I don't think it's necessary personally. In a moment, the next slide, you'll see it is required to be notarized. So that's something that you're going to have to find and provide, is the notary service. But as far as hiring attorneys to execute these documents, I don't think so. I worked in the dependency system as a social worker before going to law school. And I see this as something that case managers could help with, guardians ad litem could help with in a structured meeting where you sit down and go through this with the youth and have them choose, who they want to help and how they will get help in sort of like a staffing type scenario. I think that would be sufficient. And then, it'd be great to have, someone look over it, and, you've got to go get it notarized once it's complete. But that's my take.
I would just, to add to that, Caitlin, I would just say, one of the statutory definitions for when kids get an attorney is a kid with an intellectual disability. So to answer the question, if you see the need for a supported decision-making agreement, if that good faith basis to believe that the teen has an intellectual disability or needs a SDM agreement, I think that's when it triggers the need for an attorney ad litem, an attorney for the child. And I think that it would be appropriate for, that to be the substance of a staffing. And then ultimately the child's attorney should be explaining it to the teen and to the child before the child signs off, so that they have a complete understanding of what they're signing.
Yes, thank you, Christine. That's an excellent point. And yeah, an attorney ad litem should be able to, I guess what I'm trying to say is I don't think the community-based care agency needs to go out and hire or contract with an attorney to do these regularly. But yeah, an attorney ad litem would be great to shepherd that process through. Okay, so we talked about how you designating how the supporter will help, and then you want to designate in what areas they're going to help. So these listed here are some of the most common ones: making decisions about your health care, your mental health care, medical, everything, making decisions about relationships, who you're going to spend time with, whether you're going to continue to be involved with your biological parents or not, those sorts of things. Living arrangements, helping you decide where to live, if you should move, those sorts of things. Voting, finances, government benefits, contracting, employment, and travel. And so, these kind of mirror, if you'll notice, the rights, the delegable rights in Chapter 744 that can be taken away, but you can also add others. You can add anything you want. I had one recently where we specifically said we want help in a certain lawsuit, because that's what they needed. They were involved in a lawsuit. The young person was involved in a lawsuit and wanted someone to help them make decisions about whether to accept that settlement agreement or not, So you can really put anything in there. It's very tailored. Next slide. And last but not least, it has to be notarized, witnessed by two individuals who are not the supporters or the decision maker. Standard notarization requirement, but that's one that we remind our clients of routinely, because we help them create the document, but we don't do the notarization. So making sure they understand that it's not legally valid until it's signed and notarized. Next. Okay, so I wanted to add this information in, even though it's not strictly about how you use this in practice, because a lot of people are concerned about supported decision making and whether it's adequately going to protect a person with a disability. And so, again, I'll just remind you of that dignity of risk discussion that we had a little bit earlier. But because this is in the power of attorney statute in chapter 709, all of the same protections apply to powers of attorney. So there's a criminal statute, exploitation of elderly or disabled person, that can apply, and someone can get criminal sanctions. And how strong those sanctions are depends on the level to which they have exploited the person. You know, if it's large financial sums, it can be a felony. If it's something smaller, it might be a misdemeanor. But they can get prison time, just as they could if they used a power of attorney to exploit someone. So, and then under 709, the powers of attorney statutes specify the supported as a fiduciary. They have the fiduciary duty to the decision maker, and they are not able to act in the, against the decision maker's best interest. If they do, that is actionable in civil court. And then when you're using the agreement, when you're taking it around town and having your supporter help you with stuff, if you want to have another party, a third party, recognize the agreement, and you present it to them, if they're not going to accept that agreement, they have to reject it within a reasonable time. They have to do it in writing, and they have to tell you why they won't accept the agreement in writing to help you remedy it. And if they're improperly refusing to accept the agreement, just like with a power of attorney, you can sue them to enforce the agreement, and the decision maker can get attorney's fees if they prevail in that suit. Next slide. Okay, there was one question that popped up. I don't know if that's something you wanted me to address before Christine takes up the next bit.
Yep. Are you looking at the question in the chat?
I can't see it.
Okay, well, there's a question in the chat that says, in my circuit, the Sixth Circuit, we've been told that the ethics line has advised that attorneys ad litem should not get involved in these actions as it is assisting in taking away the client's rights. Any thoughts?
Right. So, and I encountered this myself. So yeah, you're going to be acting against your own client's interests if you are pursuing guardian advocacy or guardianship for them, because those are things that would take away their rights. That's correct. But I'm not the ethics line, but the way I've interpreted the advice given by the ethics line is that you can absolutely defend against guardianship or guardian advocacy, and creating these alternatives and putting them forth as alternatives to you having your client's rights taken away is a defense against that. So yes, you never want to be the one who petitions for guardian advocacy or petitions for guardianship, but I think helping defend against them, helping preserve those rights is well within bounds.
And I would just add that if you're already appointed to represent the child, it's absolutely your obligation to advise them, explain, help them understand what the process and the options are, and to seek direction from them about what their interest is in resolving it. So you can't presume anything. You have to advise and counsel your clients too. That's a good segue to Christine to switch back, and we'll try to address some of the other questions as we go along. Go ahead, Christine.
Sure. So there's a question about a 19-year-old who was in foster care and is now being cared for by the adoptive parents of a sibling, and he seems to be having intellectual issues. I'm not sure what the question there is like what's appropriate as to it seems to me if that youth is in your household, a supported decision-making agreement maybe informally is going on. You're standing in the shoes as a foster parent or a quasi parent, and so you're kind of probably doing the supported decision-making informally, but now this tool is available to to maybe formalize, and in that you can take advantage of some of those resources on the Disability Rights Florida website, in the form of powers of attorney or those SDM agreements. And so here we launch into using SDM in your practice, and interrupting the cycle of substitute decision making. Next slide. Yes. So as I kind of mentioned before, when we have a youth in the dependency system, we want to start early. As it kind of segueing off of what Caitlin says, the whole thrust of this is to allow kids to make decisions and to practice them. When we have our own kids, that happens naturally. In a family where you kind of let the leash out little by little. As they get older, they're able to make some more autonomous decisions for themselves, what electives they want to take in high school and what extracurricular activities they want to be involved with. And as they get a little bit older, whether they want to work and how they're going to get to and from. And so those practice decision making, we want to do that early, but at the very least, before the 17-year-old JR, multidisciplinary staffing should be held. So make sure if you are representing a teen that there is a Regis Little staffing, a multidisciplinary staffing, and not just the ordinary staffing, but people who should be at the table. I say the more the merrier. The child's attorney, the guardian ad litem program, the person with the placement of the teen, parents if their rights haven't been terminated, relatives and other kin-like adults who can support. Just because somebody's not a placement alternative for that teen does not mean that we should blackball them and not allow them access to some of these meetings. They, for whatever reason, they might not be a placement alternative, but they should, if they are a supporter, they should be in this meeting. Anyone that the child identifies as a potential adult supporter should be at the meeting, and anyone the guardian ad litem program has identified as a supportive adult, and we'll get into that in another slide. Next slide. And so now there's a new statutory change that's effective, or that went effective this past July, that the statewide guardian ad litem office has taken up the mantle to make sure that the teen has a supportive adult. So if you are holding that 17-year-old JR and you don't identify any supportive adults, then the SGALO should be working on that. The legislature has made a finding that caring adults provide a lifeline for kids that are aging out. And so the SGALO is going to be able to help them connect with supportive adults. And they have a framework for that. And if the child, him or herself, cannot identify a supportive adult, the SGALO will work in conjunction with the Office of Continuing Care to identify at least one supportive adult with whom the child can enter into a formal agreement for an ongoing relationship and document such agreement in the child's court file. So, that I think is a really great change because if you can imagine, some of our kids have been kept in an environment in a more of a restrictive environment, perhaps if they're in a foster care home where they don't have free access to contact relatives and they don't have free access to contact and make those supportive adult connections. Then the SGALO maybe will sit down with them and help identify someone, maybe a former teacher, maybe somebody that is in the extended family tree. The SGALO can now, by statute, is tasked with that that shaking of the trees task to find that supportive adult for that kid. And so what happens at this multidisciplinary staffing? Here are some of the things that have to happen. We need to review the child's file. So in the previous slides, we saw what happens at the JR. So this multidisciplinary staffing should happen prior to the JR so that you get things lined up for the judicial review. So if you need a new psychosocial report, that's a checkpoint for everybody to check the file and see if there's been one in the last 2 years, and if not, get a referral going so that you do have it ready for the next JR. Identify those supportive adults. If you didn't have notice of them, to invite them to the meeting, then that's an opportunity for everyone at the meeting to brainstorm who is in this child's life, who can act as a supportive adult, who can we contact to invite, how does the child feel about it, who do they think could act like a supportive adult in an SDM agreement. 39001 section 1J, it makes it part of the definition to connect to supportive adults in kin-like and kin-like connections is within the permanency definition. So we want to reframe this in the idea that this is the permanency solution for a lot of kids that are aging out, is to have those kin connections or kin-like connections. And we want to make sure that they have at least one supportive adult. And if we can't find that person, then we connect with the SGALO to bring them in and say, hey, we need help identifying a supportive adult for this teen. And so there's a question in the chat: how do we source the individuals to be the advocates? I think I'm not sure what that question goes to, but I would say that's this process. How do we source those supportive adults in the staffing prior to the staffing, and then the SGALO is now statutorily tasked with that to try and find those resources. Next slide. What happens at the multidisciplinary staffing part 2? We want to develop that case plan with the tasks that must include the activities. Again, this is prepping for that 17-year-old JR. We want to make sure that we formalize it in the case plan, and we make sure that we have a pathway to develop those relationships with supportive adults if the child doesn't already have one, increase the coping skills, and improve the emotional well-being. Again, we want to practice. If we're going to implement a system that really does least restrictive means, then how do you know what is the least restrictive means if you haven't practiced it, if you haven't allowed that teen to make decisions, to be autonomous, to have some agency in their decision-making capabilities? Again, our teens are not always going to make good decisions, but at least give them a framework in how to process decision-making and access and discuss a plan to practice those decision-making. So, maybe formalize that in the case plan, that when there's a decision to be made, how do we rope the kid in? How do we have the teen? Who's going to do that with the teen? What are the steps involved in that? And how can we get sort of a practice run going to make sure that if that process is not working, how do we readdress it? Can we implement it in different ways? That way we know if we do wind up going to a guardianship advocacy, that we have engaged in that good faith effort of trying a least restrictive means. We want to involve the child to discuss a plan for practicing that decision making and explore what a written supportive agreement would include, or who would be those decision makers. kind of going back to Caitlin's example of maybe it's not a one size fits all. Who you might rope in on financials, big purchases may not be who you look to for decisions about your car. So we can, in a written supportive agreement, you can tailor it unique for that child. Next slide. And with that, I will turn it over to Robin so that we can kind of get a little bit more into some case examples.
Thank you, Caitlin and Christine. And the one thing I will add on the previous question, which is the big question, where do we find people? So some of our communities, some of our circuits, the public guardian office will accept guardian advocacy for children, and others they will not. It's really should be your totally your last option, because kids should have people who know them and care about them that are supporting them in their decision making in whatever capacity. So handing it off to a stranger who's got a list of clients on their caseload is not ever ideal, but it is in some places an option if guardianship is required. So Jorge, if you would launch the first poll, we're going to go through and put some real facts into the situation. So let's talk about, I'm very clever with my names. We're going to talk about a few young people. The first one is Alex. So the information about Alex is on your screen. So if you've just found out you're working with Alex in whatever capacity, and Alex is 17. And so the first question is, knowing what we know about Alex, limited to these bullet points, does the Regis Little Act apply to Alex? And Jorge, I can't see how many people have voted. Can you?
We have 30 and they keep coming in. So
okay, so we'll wait a couple minutes.
Close to
Take
half.
a minute. All right. So this is our endeavor to make it interactive in this large group format. So we're going to give it a shot. Okay, so if you could post the poll, let's see what people think. To the poll, it pops up. Okay. So most of you think that the Regis Little Act applies to Alex. I think that's a pretty reasonable conclusion. Second poll question, please. Jorge, are you able to put the next poll question?
Yes. I'm about amending the other one, so I can launch this.
Sorry.
There we go. Stop sharing.
Doing our tap dance.
And there we go.
Okay. So again, knowing the very little bit you know about Alex, if you had to pick one type of support that you think Alex needs based on this information, what would you select? All right, and how are we? Let's see. We've got a bunch of folks. Okay, so I find this interesting because I thought the trigger of cerebral palsy might lead most of you to think that guardian advocacy was appropriate, because that's a kind of a direct pipeline the way the statutes are written. I'm happy to see that half of you went to the least restrictive, and impressed with those of you who said not enough information. So let me give you a little bit more information about Alex. So Alex has a very high IQ, and she is college bound, headed to an out-of-town college away from her home. So how about the next poll question, please? So what other, and this one is a short answer, what other support might Alex need? So you might be able to conclude that with an IQ of 140, pretty intellectually capacitated. But what other support might Alex need? And we'll give it a couple seconds to come in on that. I wish we could to see them live. If we were using like another tool, we could see them as they come in.
We have almost 30% participation rate. I'm waiting. This one is a short answer, so I'm kind of giving them a little bit more time to type. So I
Right.
don't want to
Yeah,
cut them off.
no, it's important. Thanks. Yeah.
All right. So it's slowed down a bit. So I'm going to go ahead and end the poll and share the results.
Okay. Are we able to see the actual answers?
I have them on my end. I did share the results.
On our end, we can just see that people answered. So if I don't know if
See view detail. I clicked on view details and I was able to see. I can read out a few of the first answers that came up.
would you please?
Yes, I have one of the okay, the first answer is appropriate housing and maybe a mentor or a guardian at college. I have education planning, housing again, assisted communication and perhaps transportation. I have supportive decision making or a dual power of attorney, a new supportive adult in a new location, finding accessible housing, financial aid support as independent student, assistance with ADL, transportation, adaptive tech. I have mobility, employment, transportation again, help communicating her decisions, and the average supports a peer in her position needs, i.e. adults who will informally serve as contact for her and as advice givers. And transportation again. Transportation seems to be one of the most popular
Right.
answers.
Wow, that is a great list of suggestions. So some of those lend themselves to some of the things that we talked about in supported decision making. A lot of them do not, but they sound like they would be good components of Alex's transition plan to make sure that she has those things that she needs in place when she leaves her current home, her current group home, and goes to college. So just because it doesn't fit neatly under the supported decision-making tool doesn't mean like, okay, we're done. It's just the start of the discussion of how do we make sure that this young person transitions effectively into their adulthood, given the constellation of issues that they have to deal with. I don't know if Caitlin or Christine, you had any other thoughts based on what you heard from the list?
I was just gonna say, I saw someone put in the disability office at the college into the chat, and that's a great suggestion. There's like ADA offices, accommodations offices, they call them different things, different places, but that's a great place to go to as well for help. But yeah, I agree that she would probably benefit from support, but certainly doesn't require any guardianship.
Okay. I think we're going to go to the next one instead of doing the fourth poll question, Jorge. Let's look at Ben. Okay, Ben also 17. Take a minute to read about Ben, and then if you could launch the first Ben poll question, which is, it's the same. This Regis Little Act apply to Ben.
The answers are coming in. And by the way, with the short answers, I had over 4 pages of answers, which are a lot of them are really great. So I'll make sure to share those with all the attendees so you can have access at all the ideas and all the answers as well.
Awesome. Thank you. Yeah. Yeah. So I think Ben is maybe a little more typical of the young people that you might see. Of course, we have young people with serious health issues like cerebral palsy, but I think it's a much smaller percentage overall of the teens that are in care right now. But kids that bounce around, that have been in the system a long time, who have displayed limited, I'll say, adulting activities, and have had these Baker Acts. I suspect y'all have worked with more folks in that realm. So what do folks think? Does the Regis Little Act apply to Ben? Yeah, so there's more of a split here, because there's no bright line criteria. We don't have a diagnosis of intellectual disability or other impairments. But I think there's a real serious question of like, what is Ben's capacity to be successful as he exits care without some assistance? So I would lean toward, and not because I want to shuffle people into anything restrictive, but I view the Regis Little law and the Regis Little staffing as an opportunity for the adults who work with young people to be thoughtful about their future and their experience. So we have transition planning mandated by statute for young people in foster care, where we have a lot of thoughts and ideas. And the law is in some ways very specific about what is to be provided to them as they transition to adulthood. I mean, when I'm talking about driver's license, birth certificate, social security card, right? The law is very prescriptive in many ways, but it is also very geared toward, I will just, I don't know, use the word typical teens, not those that have more compounding issues that might impact them in their future. And so I would encourage folks to lean toward engaging the Regis Little process to figure out, how can we best help posture this young person for a successful future? And go ahead and launch the next poll question, please, Jorge. And, based on just a little bit that we know, and those of you who already thought that he needed a Regis Little staffing, what would you pick in this regard? What seems to be appropriate for Ben? Give a minute on that.
Well, 50%, and it's slowed down. So I'm about to end the poll and let's share the results.
Okay, so this one's a little bit more all over the place with, again, folks that are leading to supported decision making. This is another one where maybe we don't have enough information. There hasn't been an evaluation. As Christine mentioned, one of the requirements for Regis Little coming into it is to be able to get a updated psychosocial evaluation. Folks, I don't know how many folks have been using comprehensive behavioral health assessments. We know that CBHAs have to be done when children enter into care, but they are a Medicaid service that can be covered up to once a year, no more than once a year. The Medicaid will pay for a CBHA. When you've got a kid that's been bouncing around and, you're coming up on this issue of like, what help does this person need? That's a tool that can be in your toolbox throughout their lifetime in care to stay on top of what are their actual needs. What are we missing? Are things falling through the cracks? Are these RTCs and Baker Acts indicative of a serious and persistent mental illness? Are they behavior issues that, can be assisted with mentoring and other adult support. So really unclear. I'm going to take a quick look at, I'm seeing some chats. So, and if you're looking at the chat, you'll see a chat from Deborah Schroth, who was one of the proponents of the Regis Little Act, and she's one of the experts that I rely on. And I like her suggestion that the act should be applied to all 17-year-olds to make sure that no one is slipping through the cracks. And I appreciate that, Deborah, from typing up. And Patty is suggesting a neuropsychological evaluation, giving what they know. And Megan is saying more than a CBHA. And that's for sure. When you have specific evaluations that you identify that are appropriate for a young person, that is always preferable over a CBHA. I just want to remind you that the CBHAs are available throughout the lifetime of the case. If you just want to get a broader biopsychosocial snapshot of the young person and what they need and what they could benefit from. Okay, so B is asking, what if Ben doesn't agree that he needs assistance? You would have to follow his express wishes, and that is absolutely true. But you don't just take Ben's decision and walk away. You counsel and advise Ben. You ask, you know, you help Ben understand the options, the consequences of acting or not acting. And, you know, as an attorney for Ben, it is your job, excuse me, to help Ben figure out his path in life and what supports can help him achieve that. So, absolutely, you cannot push for taking away any of his rights or contradicting anything that he wants, but that doesn't mean you can't counsel him and help him try to get to good solutions that will help him going forward. And so, Patty, that is a good question. Jorge, could you do the fourth poll question for Ben? And that question is going to ask the next one, please. Question number 8. We're going to switch that to what other information do we need? So,
Let me end the other one so I can start.
Yeah, thanks. I'm switching around on him. Okay, so that's a good question. Patty had asked, does Ben have an IEP? What other information do we need to know about Ben to help him? Oh, I do have a little more information I'm going to give you about Ben. Here's some other information you need to know. Ben is getting both SSI and his own disability and survivor benefits from his father. And folks in his life are concerned that his relatives want his money.
We have about 15, 16, that keeps going in. I'm gonna give it a few more seconds to let people finish typing their answers and I'll start reading them out loud.
Great.
That new curveball that we have here on the screen.
Yeah, I've never tried a short answer poll before, so.
Maybe the chat, maybe like if we want to make it more visible, right? All right, so we have 33. I'm gonna go ahead and end it and I'll give the details. Let's see what we have. Okay, so what additional information we have? Does he believe that he needs help and is he receptive? We have a status of mental health, psychiatric care prior to usage of SSI or SSA funds. We have an IQ test, intellectual and adaptive functioning, school records, medical records. Has he ever been offered training, education in cooking, etc., independent living skills? We have IEP, CBHA, and diagnosis for VA acts. What skills does he have? What does he want to do? Where does he want to live? IQ again. We have evaluation assessments, diagnosis from Baker Act. Does he have an ABLE account? We have why didn't he learn how to do things? Perhaps he was never taught. Perhaps he thinks men should have to work done for him. Also need to know what is his capacity for making decisions. And vocational help. We have 3 pages of this. I'll make sure to share all of these results with all the attendees. So I'm gonna pass it back to you, Rob.
Great. Again, great list of questions, things that we would need to know before we know whether we can, you know, really jump into counseling Ben and moving process. I also want to suggest to you that what we haven't talked about with Ben are what are his strengths? What is he good at? What is he like? You know, so many times we come into a staffing and I heard a story about one where they went around the table and the facilitator asked folks, what is one thing this child is really good at? And in a room of 15 people sitting around the table, nobody could answer that question. So the facilitator said, we're done here. We'll come back in, 5 days, and you all need to be able to answer that question. So we so many times focus on deficits and problems and what they don't know and what they can't do. And how do we help and really understanding people if we don't know them? And everybody's good at something, and what their wants and interests are. So this has been a good chat about Ben. Let's just take a quick look at our last person, Cam. Cam has Down syndrome, and we'll do this one real quickly. Does the Regis Little Act apply to Cam? I think, Jorge, let's just close that one and get a quick snapshot and we can move on to so most of you agree with Down syndrome, it applies. So let's go to the next question about what you think Cam might need for assistance. Take a look at that, the Cam situation with the EO2 as a caregiver. And this is great. Cam has a lot of support. All right, let's see what folks think about what Cam needs. Okay, so between the guardianship and guardian advocacy, that's well over half of folks think that Cam needs one or the other. So I am guessing that the folks who answer that question were pretty comfortable that Cam has a maternal aunt who can, fulfill that role. But it turns out Cam's aunt is only willing to keep Cam until she turns 18 because the aunt is leaving town for graduate school. So now rethinking with additional information. Jorge, can you do the next poll question? So knowing what we know now, let's talk about what additional support Cam might need.
The question probably displays Ben, but we're referring to Cam on this one.
Yeah, this is Cam. What other support might Cam? Oh yeah, sorry. There's a typo in there, but we were talking about Cam. And while you guys are answering that, are caretakers considered legally negligent if they do not pursue SDM? No, I don't believe that there's any statutory basis for holding a caregiver negligent. I'm not sure if the question is about someone who is under 18 and what's going to happen to them after they turn 18. We've we've talked about this in the context of foster care, where the state of Florida is legally responsible for children when they turn 18. As Caitlin mentioned before, everyone is presumed capacitated unless they're proven by a court to be otherwise. And so, yeah, I don't, I'd be curious to talk to you offline about what would get you to that place. Pose that question. Caitlin, do you have anything you want to add on that question?
You're talking about the question of caretakers being legally negligent?
Yeah.
Yeah, that's not something I've encountered before, and I don't think so. I don't think that I mean, there's certainly no like clear statutory like liability for not doing that, and I think that'd be kind of a hard argument to make. That you're legally negligent for not pursuing like a specific alternative. I think that if you did have someone in your care that was vulnerable and needed care and you weren't providing that, you might be looking at some neglect issues. But in relation to the SDM itself, I've never seen that before.
Jorge, you want to tell us some of the things that some of the answers that we got?
So what other support might CAM need? We have support at school, home, life skills, etc. Similar to Ben. We have APD waiver, housing guardian. We have guardianship, perhaps could aunt help with decision making from afar. He will likely need housing, perhaps APD home. We have living arrangements to support staying in Florida, post high school plan. We have decision making, money management, referral to ADP, extended foster care placement, educational and financial supports. We have support for finding a place, a payee, supported decision making. We have housing, financial management, transportation, assistance with applying to college. We have group home placement with APD, and we have a few more pages of these results. So passing back on to you, Robin.
What you're going to share. And so I appreciate it. Thank you all for attending today. I hope you found this interesting. I hope it will make you think the next time you're working with a young person that has had concerns or issues in their life. And, I'm sitting here in my office with my husband who used to work at Disability Rights Florida, and he got a call one day from someone asking about community plans, a transition for a young woman who was exiting a SIP, an inpatient psychiatric program, at her 18th birthday. And when he acquired what the transition plan was for her, the response was Baker Act. The plan was to bring her back to her hometown and then Baker Act. Baker Act is not a transition plan, right? We need to work upfront early on to figure out what those appropriate services are, and what the natural supports are and how we can enhance them so that all young people can transition to adulthood and be healthy and thrive. So we'll stay on for a minute and answer additional chat questions. But we appreciate your attendance and your thought about these young people as you go forward. So,
hey, Robin, can I plug really quick? Just the suggestion that you don't wait until 17 and a half or 18 or even 17 to start thinking about this. If you have someone that you suspect is going to get there, there's no reason that you can't start helping them practice learning how to make decisions with SDM much earlier, 14, 15, just help any kid really to help them learn the process of weighing pros and cons and how to make a decision. Because you may be able to avoid the necessity for any of this if you start early enough with them and they've learned and integrated this into their life. So yeah, don't feel like it's not like guardianship that pops, clicks in the day they turn 18. There's certainly no reason to wait.
I know we had other questions in the Q&A. I did want to add some quick housekeeping items. I did post the CLE code, but just in case you're listening in and you want to write it down, it's 2408028N. This is all going to go out on an automatic email from Zoom if you registered. We will also post it online so people can find it in case they didn't register, or even if they didn't attend, they will have access to this. We are sharing some materials. The slides that were used today, we're gonna upload them to a materials folder. I've been dropping the link here, but I'll also include the link on the YouTube recording. It will go out on the email materials. And if any of you need a certificate of completion and attendance, feel free to email me. I'll drop my email again in the chat. You will see it on the email from Zoom as well. And I'll start getting those ready for you. So I'll email all those to you. So I want to make sure that if there's any other questions before we officially wrap up, I'm kind of going through the chat. Robin, there's a few questions in the Q&A. I don't know if you want to answer them.
I would just say, so not enough information. The kid on your caseload sounds like my 16-year-old. And so not enough information to say that they need help with decision making. Clearly, they're not making good decisions as a teenager, but we have that that making bad decisions, as Caitlin said, is not sufficient to support an intervention that requires someone else to make decisions for them. So I'm sure that's not satisfying to you, but I know that any of us would be happy to talk to you offline about the young person in your situation, Amanda. And I think we answered the other ones online. So thanks, everybody.
Thank you again to all of our speakers for this amazing presentation, and thank you everybody that attended and participated. All these questions and answers that Robin was answering there, like I'm gonna share all these answers with all the people that registered. And yeah, we hope you found this session very valuable and that it provided useful takeaways for your work. As I said, the Zoom email is going to go out within 24 hours. You're going to have my contact information. If there's anything you need, do not hesitate to ask. So thank you again for our amazing speaker lineup, and we look forward to seeing you again at future events. Have a great afternoon, everybody.
Bye-bye.